Thank you for joining um, what is Defend Our Democracy's first webinar that is going to be part of a series of webinars focused on constitutionalism. Today's webinar is entitled Power Negotiation and the Nation, the Creation of South Africa's Constitution. It's quite a tongue twister, and I should have rehearsed that before trying to say it for the first time here. But we're glad that you could join us today, and I think it promises to be quite an interesting and timely webinar, particularly given that we are in Heritage Month. As I was preparing for the webinar, some of the things I was thinking about are really what is the identity of South Africa? What is the actual heritage that we celebrate? And what role has the Constitution had in shaping that identity? There are obviously constitutional theories about whether constitutions shape a society or they mirror a society, and those are not mutually exclusive. They can begin by mirroring a society and then shape it in a vastly different way, or like ours, be set out to shape a society and transition it from one dispensation to the next. And so today we're going to be looking at that process of getting from the apartheid era to the constitutional dispensation and the role that the Constitution itself played in that. But we all know that that was a contested terrain, that it was not an easy process, nor was it something that was largely agreed upon and that miraculously everybody felt consensus toward. We know that it was a process of that took place in the context of political turmoil and unrest and violence in the country. We know that there were differing political parties with differing views and values and inputs who all wanted different things from one document. And we know that there were negotiations that had to take place and that there were compromises that were made. And so in this introductory webinar, we're really going to be exploring some of those themes and looking at these different themes. We have a really, really excellent panel, and I don't want to spend too much more time on an introduction because I really just want to dive into their contributions. And so I'll start by introducing Mr. Rolf Meyer. And maybe let me just say that none of the participants today need an introduction. All three of their CVs are extensive, and I can't go through everything. So I'm just going to be picking up on small bits of it, and they'll tell you a little bit more about their role and the relevance of their insight into today's webinar. So Mr. Meyer was the chief negotiator for the National Party government at the time of the negotiations. He subsequently was in the cabinet of Nelson Mandela in the portfolio of constitutional affairs. He then obviously went on to be involved in a number of peace processes around the world, and today is involved and I think heads up an initiative called In Transformation Initiative. Mr. Hassan Ibrahim, who was the national administrator of the ANC's National Negotiations Commission. He joins us and was also part of the Transitional Executive Committee, which was really tasked with transitioning between the two dispensations. He was offered the position of the Chief Executive Officer of the Constitutional Assembly in 1994, and again, also went on to be involved in consultation and constitution-making processes post his work in South Africa, if you can say post his work, in places like Sudan and Somalia. He's written extensively on constitution making, and one of the publications is something I read in preparation for today, and we'll maybe be talking about some of his views from those publications as well. And lastly, Advocate Palesa Ncholo, who is an LLM graduate from the University of Cambridge. She was one of 7 legal experts who was appointed during 1996 at the time when Parliament had constituted itself as the Constitutional Assembly. And she advised them on the process in relation thereto. So these were on the principles, the values, and contributions and inputs from different political parties and the themes that everybody wanted to see and needed to find expression in the Constitution. She's also gone on to, or post that, was the special legal advisor to the Deputy Minister of Justice, and then subsequently advised 2 justice ministers thereafter. Obviously, a really, really knowledgeable and insightful panel who I'm very excited to engage with, and we are very grateful to all of them for availing their time to be with us today. Oh. And so without any further ado, maybe just one more thing in terms of how we're going to facilitate today. If you do have any questions, any comments while the speakers are presenting, please feel free to put them in the chat, and then we will have a time for going through all of those questions at the end of the presentations. So Mr. Ibrahim, can I hand over to you then?
Thank you very much. Yes. Okay. Can you hear me?
Yeah, go ahead. We
Okay,
can hear
that's
you. We just
perfect.
can't see you. Do you maybe want to turn your video on, or you're going to be doing it?
I thought I had a presentation available for it, and I thought it would be better to see a presentation rather than to look at my face as I was talking.
That's perfect. You're welcome to share your screen as well.
Oh, how do I go about doing that?
Okay, no problem.
Share.
Let's do
Okay,
this.
share.
Yes.
Yeah, that's it. That's
Got
it.
it?
Yep. Share. Okay.
Perfect.
That's it. Okay. So essentially, if I can, okay, how do I hide the screen of the participants? Chat participants. Okay.
You can even you can enlarge your PowerPoint, and as you go through it, we'll be seeing it. And if there's any problems, I'll just bring it to your attention, so you don't have to worry about what's going on here.
That's perfect. Okay.
Perfect.
Let me start off by saying, when we talk about constitutions, we often purely look at what took place in South Africa rather than looking at the broader context within which the constitution and constitutional process unfolded. And so I think context is always an important part of it. There are macro levels at an international level. There are regional issues. And of course, naturally, there are national factors that come into play when dealing with constitutions. When we look at the history of constitutions, the international context does matter, because there are a certain generation of constitutions that came into play primarily after the Second World War. The Second World War, you saw a process of decolonization, establishment of structures like the United Nations and a whole series of international structures. You saw nation states emerging and so on. And so you saw a generation of constitutions coming into play. And in fact, you also saw discussion throughout the world on the question of the Bill of Rights and elaboration on different rights as such. So the international context had a major impact. And then, of course, more directly that impacted on the way in which things took place in South Africa was subsequent to the collapse of the Berlin Wall. And that had a fairly big sort of role to play. Maybe if I do it this way, that's better. Yes. So the collapse of the Berlin Wall had a major impact in the way in which the international order took place and the way in which it unfolded. Following that, within that context, was of course the African context, and you saw the struggles against decolonization, colonialism and decolonization. More relevant to South Africa was the Harare Declaration as it took place. Now, very important event in Southern Africa as it impacted on South Africa and the process that unfolded was clearly the Kwetu Konavale battle that took place, and that changed the way in which South Africans saw the future of their discussions and so on. So in the national context, of course, we had major issues relating to somebody else is dealing with this. Oh, okay.
Are you fine? Sorry about that.
I'm not sure how to. Oh, screen sharing has stopped. Okay. I'm if need be, I'm happy to proceed.
No, Mr. Ibrahim, let's do your screen again. Sorry about that. Maybe if you if you can just share your screen again, it was working perfectly. I'm not sure.
Yeah. No. Share options. Zoom. I can't see the thing on the share screen any longer. Oh, it's gone now.
At the bottom of the Zoom panel, does it say share screen? No?
It says no. No, it just says share.
Let's see if I can try it from my side. If I put your video off, let's see if we can do it that way. Sorry about this, everybody.
No.
Okay, do you want to just see now if you'd be able to share your screen? Does it pop up?
No, it doesn't. No, sorry.
Oh, sorry about that. I don't know why this is happening. Okay, maybe you can continue, and if on your side you can just go through your presentation.
Okay.
I'll maybe just ask Zinzi and Rejabile to see.
Let me carry on. So
Okay.
in South Africa, the national context, of course, nationally, the economy was failing. There was a realization that the continuation of the war was not a viable process and that something had to be done. And there was, of course, intensifying civil strife. And the struggles within South Africa started intensifying and becoming much more violent and much more difficult. And neither side was winning, neither the liberation struggles nor the apartheid government. Share my video later. Okay, there's it. Okay, so in fact, there was a clear sense among the leadership of South Africa across the board that it was necessary to actually have some negotiation. So subject to compromises being made, peace was really the most, what's happening here? Okay. Subject to compromises being made, peace was really the most practical option. Now, my last bullet point on this slide is really Gaza in the future. What I want to say is that we've had a generation of constitutions that came into play after the collapse of the Berlin Wall. And what I am of the firm view is that the world order is about to change, and the way it impacts on constitutions will also change. And there's a number of factors coming out of the situation in Gaza. The situation in Gaza is one in which we see a return of genocide in the most violent and vicious form. But it's not just genocide. It is also to some extent a collapse of the international order, where international order, international
Mr. Ibrahim, I'm so sorry about that. I think one of the participants, and it's very difficult to recognize who was doing it, was basically taking hold of the screen and then just putting some profane things on the screen. So what I've done now is I've suspended all participants from being able to do anything, and I'll have to unmute them. So I'm sending you a request now to unmute. Just let me know if you are able to.
Okay. Yes.
Okay, that's perfect. And then you can go ahead. I'm so sorry for the interruption.
Not a problem. So in effect, what I'm saying is that the situation in Gaza and the way in which it is unfolding will impact on constitutions in the future. And certainly the international order is impacted on by what is taking place in Gaza. Basically, the power relations and the failure of countries to abide by international law, international order, is certainly something that will impact on the way in which constitutions are made. Perhaps I go on right. Okay. Perhaps I go on to the. Now it's creating a problem. I can't see. I can't.
Can you see the
Hello.
screen? Can you
I
see the
can see
screen?
the screen. I can't manage it.
Okay, that's fine. So Zinzi is
slide
going to
it.
manage it for you. So
Very good. Okay.
she'll work with it as you're speaking.
Okay. If perhaps I can go on to the next slide.
Okay, Zinzi.
Okay.
Just the next
So-
one, Zinzi. Slide 3.
Let's see. Ah,
That's perfect.
Okay. Okay, I thought I'd just put in a fun fact because many of us who have studied constitutions were taught in school that constitutions are forever, and that's not really true. Uh, I had the pleasure of working with Tom Ginsburg and a number of other people. And Tom Ginsburg he's from the University of Chicago. They did an extensive study on constitutions from throughout the world. And what they actually discovered that the durability of written constitutions is somewhat limited, and it's limited to 17 years. And they found that generally, if you studied all constitutions in the world, you'll discover that over a period of 17 years, constitutions actually change. And there were a number of findings that are important. And I say they're important because they have relevance to us as well. Firstly, they found that there's constitutional fragility. Despite being designed to express enduring and national principles and limit government power, constitutions are surprisingly short-lived. It's only really the American Constitution that has lasted for a long time, but on average, most constitutions last only 17 years, and with a median of only 8 years. Why so short? Well, Ginsburg and his colleagues argued that the constitutional change often correlates with regime change, political instability, or the need to adapt to new social realities. They also found that the design features, like how inclusive the drafting process is, how flexible, and the amendments process is, and how specific the document is, can significantly impact or affect a constitution's longevity. So it's really only the American Constitution that has been identified as the outlier and something totally different. And generally in universities, we are always taught that constitutions are forever, and it isn't. And so essentially, that's the point I wanted to make. If I can go to the next slide. I was talking about context and so on, and I thought that the proper place to start off would really be or at the national level, the Harare Declaration, adopted in October 1989 by the Organization of African Unity Ad Hoc Committee on Southern Africa. It was a pivotal document that really laid the framework for how, and they saw apartheid ending through a process of negotiations. And the core principles really identified: one, rejection of apartheid. The declaration affirmed that apartheid was incompatible with peace, justice, and human dignity across Africa. Secondly, a commitment to negotiations. It emphasized that peaceful resolution to South Africa's conflict must be based on justice and equality and for all people. If I may pause on that point, is that most countries that were involved in the OAU at that point in time also were clear that it was not going to be impossible to defeat the apartheid government militarily. And at some point, it was going to be necessary to enter into negotiations. And the war itself was spilling beyond the borders of South Africa and impacting on a number of other countries. And people felt that the only way forward would be negotiations. And therefore, Harare Declaration helped in defining the way in which that process would unfold. And of course, it looked at self-determination. It recognized the right of South Africans to determine their own future and the political system without external imposition. One can only look at what is happening internationally, in mediation efforts and how that unfolds to realize how wise this particular position was. If I can go to the next slide. So the Harare Declaration identified preconditions for negotiations, and you can see the wisdom of a leader like Oliver Tambo, which came through very sharply and very clearly that negotiations should take place, but there had to be preconditions. Firstly, release of political prisoners, including Nelson Mandela, unbanning of political organizations, the release of exiles, and the freedom for all South Africans to participate in political life. And of course, the cessation of violence and the dismantling of apartheid laws and structures. So that laid the basis on which negotiations could take place. And that's defined the whole process But it defined it in a way in which it wasn't purely a South African initiative. It was an initiative that was firstly started at the OAU and then taken to the UN structures as well. And so there was broad acceptance of what was contained in the Harare Declaration. And I think, the diplomatic strategy, the ANC led by Oliver Tambo, which was really, I think, a remarkable leader, used the declaration to rally support from the African states and the international community, ensuring that negotiations would not entrench racial power, but lead to a non-racial democratic South Africa. If I may move on. So I was then asked what were the main political, social, historical factors that necessitated the creation of a new constitution in South Africa in the early 1990s. Can go on. So a big issue at the beginning of the negotiations was really the mandate to draft a constitution. And so the argument presented by the African National Congress was really that they had no mandate to draft a constitution. Only an elected body could draft a constitution. Hence, you needed to have an election, and that election would determine who the people would be in a constituent assembly, as it was called then, and they needed a mandate to draft. However, all parties recognized that, in fact, before you drafted a constitution, you needed a peace agreement. There needed to be peace in the country so as to create what they referred to as a climate conducive to the process of negotiations. And so you had a record of compromises that were reached, and we'll talk about that just now. And essentially, what came out was really to find a balance between the will of the majority and the concerns of minorities. And so essentially, the beginning of the constitutional process really played around with the issues of how to balance these two aspects. And very clearly, what came to the fore, and you'll see that in the Harare Declaration as well, is the establishment of a Bill of Rights, because there were key constitutional principles that were critical, and the Bill of Rights or human rights was critical related to that. Then, of course, was on the preparation and moving towards the drafting of the constitution came the restructuring of the state into 9 provinces, and that became one of the key issues, which I'll talk about later, and maybe Rolf would also want to expand better because he had much more intimate knowledge on this particular question. If I may proceed to the next slide. So the most significant challenges that were faced really was found in the settlement of the 34 constitutional principles, which captured the core compromises. And I think the way in which South Africans crafted these constitutional principles, which embodied a lot of the constitutional the compromises, this process and the approach, the methodology, was something that throughout the world, people have found a very useful and helpful way in which to manage their processes. And so you'll find throughout the world constitutions that were made after that, were made on the basis and the foundation of constitutional principles similar to that which we put forward. And so the process was more difficult, really, than the substance. And this is what I want to focus on for a moment, because thousands of people really lost their lives during the process leading up to the adoption of the Constitution. In fact, the Truth and Reconciliation Commission, they calculated that there were more than 14,000 people that were killed between 1990 and 1994 when the interim constitution came into play. And so this was a pressure on the political leadership to actually find a solution and to come up with compromise that they felt would afford the country a better state and therefore a constitution as well. The next question is something I If I can go to the next slide. Okay, how did the diverse political ideologies of negotiating parties influence the drafting of the constitution? While I don't want to pass the buck and let Ruth answer a lot of this because he played a leading role in it. What I want to say here is that, and I'll come up with deal with some of these issues a little later, more than a diverse ideological difference, because the parties that sat around the table, sometimes from 19 to I think about 23 parties, was not ideological difference. It was really political interests and the management of constituencies. So you found sometimes tribal, ethnic, racial constituencies at play in defining issues. So modern ideologies was really how to manage the different constituencies and political interests of the diverse parties that were sitting around the table. So I wouldn't quite frame the question as really the diverse political ideologies. I would consider it slightly differently. If I may go on to the next slide. What were the major compromises made, and how did these impact on the final constitution? Well, different people would have different approaches to answering this question. I thought about it and I thought, well, one of the major compromises I thought, and I raise this because I think it's such a relevant point even now, is restructuring of the state and the country into 9 provinces. South Africa previously had 4 provinces. It was managed by a government that had 200 people at the national level. There were 4 provinces managed by 10 people in each of those executives. We ended up with 9 provinces, 490 people at the national level, and a large number of people in each of the 9 provinces with a huge government. And so that structure essentially, to some extent, represented one of the key compromises. The second compromise, I thought, was in the electoral system. The electoral system was identified to be in a way in which at least all parties would feel satisfied that they would be able to have a fair shake at attaining and playing a role within the body politic. Then the majority meeting the concerns of minorities. I think I raised this before. It's a theme that cuts across. I think it's really fine that that's where the major compromise took place, and the way in which that play between the meeting of the majority, the will of the majority and the concerns of the minorities, how that played itself out in the 34 constitutional principles and throughout the Constitution, had a very big impact, and those were a lot of the compromises. So the negotiation of South Africa's post-apartheid constitution was really, I think, a masterclass in political compromise, balancing demands of the liberation and the fears of entrenched power. And so what came out really was that it was found that we needed to have an interim constitution and a phased transition, and that was part of the solution. So it wasn't a simple case of having an election, having a majority, you'd have a constituent assembly and adopt a constitution. It was not a simple linear road. There were challenges, and those were the compromises that needed to unfold. If I can go to the next slide.
Mr. David, I'm sorry to interrupt you.
Yeah,
You have
yeah.
about 5 minutes left.
Oh, good God. Okay, I better move
Sorry.
fast. Okay, thanks. Thank you for telling me. So instead of jumping straight into the constitution, parties agreed to an interim constitution in 1993. This allowed for the democratic elections in 1994, followed by the Constitutional Assembly to draft the final version. So it then gave time for trust building and broader participation. Majority rule versus minority safeguards. So the NT wanted majority rule, while the National Party feared that domination, and that balance needed to be found. Can I move on to the next slide? So the Bill of Rights and the constitutional principles were entrenched to protect individual and minority rights. So you find that cutting across not only the constitutional principle, but you'll find that embodied in the Bill of Rights as well. So the final constitution had to comply with these principles, ensuring checks and balances. Very importantly was the two-thirds majority requirement. And that meant that, to adopt a final constitution, a two-thirds majority was required. The ANC didn't have a majority, but it had a majority, but not two-thirds. And therefore, they were forced into negotiating and finding consensus with other parties like the National Party and the IFP and looking at how to deal with those compromises. Can I go to the next slide? Okay. Very important in the compromises were issues relating to the security forces and the civil service continuity. To avoid a destabilization, the ANC agreed to retain existing civil servants and security personnel, including apartheid-era officials. This ensured institutional continuity while reforms were gradually introduced. Then, of course, was the Truth and Reconciliation Commission, which was very important because a big debate at that point in time was a question of immunities and amnesties and how to deal with that. Last point on the slide is a very important one for me because one of the issues that wasn't dealt with in the Constitution was really the local government, and neither was the structure of the judicial branch of government dealt with properly. So you'll find in the schedules of the Constitution, it suggests that the Minister of Justice is required to actually come back and review the question of the judicial branch and find that in place. So you'll find that in the later years, in 2011, we had a process to look at the judicial branch of government and how that should be dealt with. Can I go to the next slide, please? Okay. So the most important elements of the Constitution, really, I think, in my opinion, was Chapter 9, institutions supporting a constitutional democracy. That was novel. It was taken up by many other countries dealing with constitutions. I think our Bill of Rights was really outstanding, still remains an outstanding legal document that is still considered by most constitutionalists as of a superior quality. And then, of course, notwithstanding the fact that we hadn't completed the negotiation on the judicial branch of government, especially looking at the question of independence and so on, but our judicial independence as currently embodied in the Constitution afforded us an opportunity to have the stability that we otherwise have. Can I go to the next slide? Okay. Given the current climate, how should we approach the discussions regarding potential amendments to the Constitution? That's I think with great anticipation and hope. My own opinion is that I think there is a lot that is happening in the country, a lot that is happening in the region, a lot that is even happening internationally, that calls on us to actually consider how the Constitution should be amended. And if Tom Ginsburg is correct, and I think he is, then we certainly should be looking at reviewing the Constitution. And I'm sure the current discussions that are unfolding in the dialogue process, and perhaps Ruth could talk better and more competently about that, will lead to discussions that will deal with potential amendments to the Constitution and how that should be reviewed. I'm, as I said at the beginning, I'm of the firm view that changes in the world order, specifically looking at Gaza and what comes out of that, is of phenomenal importance. And so people interested in constitutional law will certainly be looking at the unfolding of that process and what happens there, that war, and how things take place. The third point, I think, is of fundamental importance in South Africa: governance and accountability. Those are issues that will be considered, no doubt, as serious issues as potential amendments in the Constitution. Review of the provincial and local government. I mean, the reality is that many of our provinces are still not financially viable institutions. And a serious look at the Constitution will be required to actually consider how that can be maintained and how a new dispensation could take place. Local government, I think, as we have heard in the last week, is a major, it's in a crisis and begs for amendments and change. And I think the way in which our experience really calls for fundamental changes taking place. And then last point I want to make is that I think the electoral system as well is something that desperately needs change, which would allow for greater accountability, direct responsibility, and so on. I think that should be something that should be allowed. Chairperson, I'm sorry I took more than the time I was allowed, but
No.
yes.
You're perfectly fine. Thank you. Thank you so much, Mr. Ibrahim. And I'm so sorry for all of the technical stuff that happened during your presentation. I'm going to hand over straight to you, Mr. Mayor, and we'll go back into a question and answer at the end of the session. If you can keep it to just over 15 minutes, that will be great. But no worries. I'll work around it if not. Thank you.
Thank you, Kirsten. I will try to make up time. Thank you, first of all, for the invitation to participate. And I would like to thank Defend Democracy in particular for initiating this webinar series. I think it's very important that we use this kind of opportunity to reflect on where we're coming from, what are the challenges of today, and what have we learned from our own history with regard to the challenges that we find ourselves in. I want to thank also Hassan for giving the context and the background. It's very easy now for me to follow in his slipstream, and I will try to respond to some of the points that he had suggested I should respond to. Let me first of all just remind ourselves, and I want to note that I see there are a number of formidable observers from the time that we're talking about 30 years ago in the audience, and players at the time, people who took care of what happened at the time, particularly during the transition from apartheid to democracy. I see inter alia Justice Johan Kriegler is in the audience. So I immediately said to myself, I have to keep myself under control and make sure that I don't say things that could be contestable. But nevertheless, whatever we are saying here as participants in this panel reflect our personal views or the positions that we held during the negotiations. So let me start off by reminding ourselves that when the whole process started in 1990, after the release of President Mandela and the unbanning of the organizations, immediately almost a period of great political contestation started. And like Hassan was pointing out, 14,000 deaths took place as a result of political violence in that period between 1990 and 1994. This was, of course, a big problem to address by the political leadership, and in the end, it was only through the intervention of the religious leadership of Bishop Tutu, Johan Heinz, and others, and business leadership that we succeeded in coming together in June of 91. And I was present during that moment. I will never forget it because it was really the first moment where we, from the opposing sides in the South African national state at the time, came together to negotiate. And we were tasked to negotiate what became known as the National Peace Accord, which is a very important document to set the base for what followed. I think, unfortunately, often too little is being made of the importance of that document and the structures that it created. Inter alia, the peace committees at the local level that took care of the violence, but also the contestation that arose in that 2-year period since the release of President Mandela. So the peace accord came, and then it enabled us to start the negotiations, as we all know, through the process that became known as CODESA. And let me remind us of the fact that CODESA actually was only at a very short life. It was only in place for about 6 months or even less, from December 91 to around about May of 92. CODESA 2, as it was called then, was collapsed, and that was the end of CODESA. So the famous word that is being used to describe the South African peacemaking or negotiating process as CODESA is actually not correct, because a year later, that same process was followed by something that was called the multi-party negotiating process. Nevertheless, to go back to that period of really difficult beginnings, the political violence, and the uncertainty that existed between the parties, mainly the ANC on the one side and the National Party on the other side, to find each other, to set the ground for real negotiations was not easy. But we succeeded in coming together and CODESA came about. And then there was something in the background that was right there from the beginning, but we didn't speak about it. On the one side, there was the Harare Declaration, and Hassan was very good at pointing that out, the content of the Harare Declaration, which is basically the departure point for the ANC during the negotiations. On the other side, the National Party had this almost obsession about the protection of group rights and or minority rights. But group rights, it was called. And that, of course, was completely opposite to the ideal of the ANC of creating a democratic South Africa that provides for one person, one vote on an equal basis. Group rights, on the other hand, as proposed by the National Party in the early documentation of CODESA, you will find it, provided for a way in which the minorities would have had protection for veto rights and or other sorts of concocted ideas. I can say it today because I was fortunately not part of those proposals. But nevertheless, this was the contestation mainly between the two main political actors. And it was there right through the first 6 months of the negotiations in 1992. In the end, that period of the negotiations didn't succeed. CODESA 2 collapsed in May of 92. And a month later came Boipatong. And Boipatong caused a complete breakdown of all negotiations at that stage, also bilaterally between the ANC and the National Party government. It was a devastating moment. I will never forget it because I just had to take over as the chief negotiator for the National Party government. And it was for literally a few minutes in the balance whether we would go back to the bush or whether there would be a continuation of a peaceful negotiating process. Fortunately, in the weeks that followed, Cyril Ramaphosa and I were tasked to find a way forward, mandated by our principals, President Mandela and President de Klerk. And after 3 months, I think the real settlement in the South African case came about through what became known as the Record of Understanding. A document that was initially aimed at finding a solution for Boipatong, the Boipatong massacre, which you will recall was the result of the contestation, the violent contestation, but government forces were blamed of supporting the Inkatha warriors in that situation that resulted in the Boipatong massacre. So that was the start of that 3-month period of negotiations between June of 92 and September of 92. But it was more than that. And for me, it was the turning moment for us within the National Party thinking, because it forced us to go back to the drawing board and say to ourselves, what is it that we really want from the future instead of what it is that we want to protect from the past? And obviously, the whole subject of group rights and or minority protection was in the mix as far as that is. Actually, that was the burning issue that had to be addressed. So the Record of Understanding in the first 1.5 page of that document addressed this whole context of where do we go into the future? And once we had agreement on that, the ANC and the National Party was on the same page, setting out the future, determining that we will seek a democracy in South Africa that gives equal rights to every individual protected in the Constitution. It furthermore provided for the constitutional principles to be agreed upon, as Hassan was highlighting, and furthermore, the recognition that there will be a Bill of Rights in the future Constitution and protected by a constitutional court as part of the first phase of the new constitutional dispensation. It also furthermore, this record of understanding, confirmed that there will be two phases of constitution making. An interim constitution followed by an elected body from all South Africans, in other words, the elected parliament that will also act as a constitutional assembly that will draft the final constitution as it became the fact. So the record of understanding, in my mind, dealt with the departure points where we came from. On the one side, the Harare Declaration, the demands of the ANC at the beginning, and the National Party's objective at the beginning to protect minority rights and or group rights. How did we go back to our constituency is an important question. We went back to our constituency to say, it's better to have protection for individual rights than for minorities, because on the basis of individual right protection, you have protection for all on an equal basis in the nation as it is. And that helped us to canvass support also within the white constituency, so to speak. So that moment of the breakdown following Boipatong, we could succeed in overcoming. And then a new process started 6 months later, the multi-party negotiating process. But again, a threat came about because of the assassination of Chris Hani. And again, the negotiations were really at the brink of collapsing if it wasn't for the leadership of President Mandela at that moment, who insisted that we should continue with the negotiations and finding a way forward, but with an agreement on a target date, setting the first election to be not more than a year later from that point. This was April of 1993. And so we could continue with the negotiations, and the threat of collapse was fortunately avoided. And then finally, we agreed on the interim constitution by November 93, and that helped us to get the transition in place from apartheid to democracy, as we all know. I just want to make a remark about, and also here confirm what Hassan mentioned inter alia, that I think 3 factors determined our success in that first phase of the constitution making, in other words, the interim constitution phase. And that was the nature of the inclusive approach that was followed. We all the time speak as if it was only the National Party on the one side and the ANC on the other side. That's not correct. There were more than 20 parties at the negotiating table at Kempton Park where we were doing the negotiations. And whether it was big or small parties, they all had the right to participate in the same way with inclusive participation rights. And I think that was part of the success. The second was the fact that we built the relationships between us as individuals, but also as parties. And that relationship developed into trust. That trust, I can say truly, still holds to today. Every person that was in that room that participated in those negotiations became a close friend almost of everybody else, in the sense that we developed that trust amongst ourselves. And the third was the fact that we took ownership of our own destiny. We didn't leave it to outsiders. No mediators were called upon to come and do the job for us. We succeeded in taking ownership and responsibility ourselves. As far as the Constitutional Assembly task is concerned, I think there's a lot to be said still about that, because it's important to remind South Africans today who claim that the Constitution was only produced by a few, to remind all of us that it was actually, like Hassan said, 600 people elected by the people of South Africa in the first democratic election who had the responsibility to draft that final constitution, and that was it. It was adopted by them all, and it was the representatives of the nation, in other words, who took the responsibility. But it was also a contesting time still. It was 2 years from May of 94 to May of 96, the period that Hassan took the leadership of the Constitutional Assembly, and the role he played was phenomenal. But it was a contesting time. I will never forget those last days before the 8th of May, 1996, when we had to sit through long hours, days and nights, and conclude on difficult matters. There was the famous six-pack deal that came about in the end. But like Hassan was saying, we were fortunate that the nature of compromise was in the air, and give and take was definitely part of the solution. Let me conclude by just saying that if one looks today at the global picture and taking examples from the conflicts that I had the opportunity to share our experience with around the world over the last 20 years or more, I came across the fact that I think one can say there are three main causes of conflict. The one is religious, the second is ethnicity, and the third is greed. There's no other description for that. Greed for power or greed for wealth. And unfortunately, we are seeing an escalation of the last one in huge factor, in huge proportions in recent times. If we just look at our continent, it's sad to say that this factor of greed for power and wealth is playing out in almost all regions of the African continent. But so it is also in other parts of the world, whether it's Asia or some parts of Latin America, it's the same thing. I don't even talk now about the Middle East. So this is the sad feature of where we find ourselves, and the period following the peace after the end of the Cold War is over, and completely new dimensions are taking shape, and we certainly are going to have in this series, I guess, also discussions about that going forward. But my very last point in this regard would be, our Constitution is the base of the nation, and we've seen it several times over the last 30 years. And the lesser we touch it, I think the better. Certainly, we must not be close to needs for constitutional amendments wherever it's appropriate. But the more we touch the Constitution, I think the more we run a risk. And I would personally warn against unnecessarily considerations of that kind, because it might touch the very foundation that we have relied on for the last 30 years, and certainly going to rely on for a very long time in the future. Thank you very much.
Thanks, Mr. Mayor. Advocate Ncholo, let me hand over to you. Again, if you can just keep it to about 17 minutes, and then we at least have a good 20 minutes for question and answer, please.
Can you hear me? Hello?
Yes, we can. Thank you.
All right. May I also just start by thanking Hassan for this broad introduction, which is giving us an important context within which our own situation unfolded, because we are not an island. We are part of the global community and the regional community. So all the factors that he raised are definitely important in understanding where we were in the process of constitution making. Equally, I would also like to thank you for this process of discussing power, constitution making, and defending our democracy. It is an important conversation that we need to have as South Africans, because we need to continuously remind ourselves if we're still aligned to our purpose of nation building and redistribution of the wealth that this country has been endowed with. So conversations like this are important only insofar as they will input in making a difference that we all want to see, we all are desperate to see happening. So I equally want to thank Rolf for his input, because it also just narrows the issues for me. He has properly elaborated the context within the nation, and that again is very important. So I will just go straight to the issues. I come into this process when the parliament had been elected in 1994 and had constituted itself into the Constituent Assembly, which was now tasked with drafting the new constitution. And the issue is, was there a power play in the process? And I really want to say, maybe as a point of departure, and this is I think, an important point that Ruth Meyer made, in that in as much as the two important and big power blocks were the ANC versus the National Party, but there were many other parties that had won the election, that were part of the Constituent Assembly, that were actually also very much involved in putting forward their aspirations of what they would like to see unfolding in the Constitution. But also we need to be mindful of the inputs by the nation. The people were sending their own understanding of what they wanted to see in the Constitution itself. So there were all the inputs that came through letters, emails, through radio stations. So the process was really consultative by nature. And all those had to be streamlined into themes, which themes went into committees of the assembly, so that they could then be processed and reduced into some form of provisions. So in as much as there were representatives in parliament or within the Constituent Assembly in the drafting, there were also further inputs that were coming from the grassroots, from the communities, from the people, which were inputting. Is there a problem?
No, Advocate Ncholo, we can see you now, and you can, yeah, you can keep going, no problem at all.
All right. So there were all those inputs that were coming from all over South Africa. So the people themselves were involved to a very great extent in this process of constitution writing. Now, our role was to advise the whole assembly in how those themes would then proceed to put forward the proposed legislative, or what one would say, the proposed provisions for each of what the particular theme would be on the values or the founding principles, what would finally be agreeable to all the parties. That is where we were coming in to give counsel to the Constituent Assembly. And our work was basically to look at it and see if, one, does it really represent what the parties are trying to achieve? And would it be efficacious if it were to be taken to court? Does it make legal sense, or have we just written a lot of words which do not carry legal weight? So that is where we came in. And basically, we had to also do some work ourselves in the background. We engaged a lot with the Canadians, and I, without necessarily going into a detail about constitutions that have endured, I think it's quite a number of countries other than the US. We engaged a lot with the Canadians, who also introduced an important principle of us drafting our provisions in the Constitution in such a way that it is accessible to the ordinary person, so that ordinary people, irrespective of their level of education, could be able to understand the rights that they've given unto themselves through their direct involvement in their own submissions, but also through their representatives who were in Parliament, having been elected in 1994. So that was really, for me, an important thrust of this. Was power important? Yes, power did have its own dynamic. But again, I think when you look at how everything was done, the concept of compromise and consensus actually gained notoriety at that process. That we need to get to a point where, as South Africans, we understand that it can never be a winner takes all, because that will definitely create instability in the country. So what would that mean? Then that entailed the leaders to the negotiations who, to be honest, it was Roof on the one side representing the National Party and the current president representing the ANC. They needed to listen, and to listen carefully to everyone's input, and to take into consideration the concerns and the aspirations of all the people who were in the Constituent Assembly, so that whatever it is that was drafted would take into consideration all those issues. And then it will be presented in a legal way that continue to carry the concerns, the beliefs, the values of all South Africans, and arrive at a provision that everyone will be happy with. So power was important, yes, but it wasn't unchecked power, if one were to put it that way. And I think Roof rightly puts it, for the longest of time, the issue of minority protections, minority rights, which, by the way, had been part and parcel of the constitutional principles of the interim constitution, was entrenched, so it could not be overlooked. So the very process of writing the final constitution was also within the backdrop of those constitutional principles of the interim constitution that had led to the elections. So it was not necessarily a process where you wrote what you liked. The principles were very important. At some point, those principles needed to be tested as to whether we look at the intentions of the drafters or we look at the spirit of what was intended to be gained, because of the tussling and the process of trying to find a compromise by all the parties involved. So yes, power played a role, but I think it was more the art of understanding that you have to restrain yourself. Even if you have majority power, you need to restrain yourself. You need to be able to listen to the concerns of everybody. You need to have the ability to carry everyone on board. And those, I think, will be the proper traits of leadership. And the issue of and this is really part and parcel of what was involved. May I just input also on the issue of provinces and why it was important to demarcate South Africa into provinces? One of the issues that I'm aware of, because we needed to go to Spain as the panel, we were sent to Spain, we were sent to Germany, and we were sent to England to go and look at the canton system in Spain. Because at the time, the late leader of the IFP, Chief Mangosuthu, was insisting that South Africa could be divided into provinces where KwaZulu-Natal becomes a standalone with its own police force and so forth, like the canton system in Spain. And we had to go to Spain and really engage with the lawyers, the politicians, and the judges there to really understand if it was working. And we had to go and look at the German system, the Bundesrat and the Bundesstaat, and how their system actually worked. And then we had to look at the British system, which is more centralized, but with very strong constituencies. And in South Africa, we needed to take into account the fact that some parts of South Africa, especially the former homelands, were not properly developed. And I think prior even to the process of constitution writing, there was a commission that was looking at redoing what were called geographically redrawing the lines of what will be provinces later on, so that you do not find the sparsity of what had been homeland system still continuing to exist. They needed to be a marrying of the developed areas with those that were less developed and so forth. So we came back with our own counsel of our own finding that at a principle and constitutional level, it could work. But as to whether that is working well, those are things that at an administrative level we need to look at. Is it because of the demarcation, or is it because of the failing of the civil service and the issues surrounding poor service delivery, corruption, and so forth? But we had the opportunity to go and experience the different systems so that we could come back and then input on what will be the salient features of the demarcations at the principal level, that is. So constitution making, I would say South Africa created something of a novelty of its own. It engaged even including the traditional leaders. The NCOP needed to be integrated because it took a bit of time before the traditional leaders understood what their role was going to be in the new constitution. So that process also needed to be engaged in so that the Amakhosi, the chiefs, could also be brought in and understand that their views are just as important. They will constitute part and parcel of the rural administration as they have been, but now with the nuance of understanding that everybody operates within the constitutional provisions that are laid out for all exercise of whether political or administrative law. So that too happened, and that is why eventually everybody could buy into the constitution, because it did not leave any portion of the South African community outside of the purview of what was being done. So insofar as the constitution making process by itself, I must say the layers that were created administratively, I think between Hassan's office and the leaders of the political parties was really the best. At the beginning, it was cumbersome. At some point, it was confusing at the beginning. But with time, as the process got traction, it actually was working very well, because everything else started at the theme committees where there were lawyers working there, and then it would be presented to the assembly, and then it would go out, and then it would to be cleaned up, maybe by the same theme committee, and then come back into plenary. Then from plenary, it goes to us, the panel of 7 legal experts. So it really was a ground swelling working environment, which I would believe South Africans took hold and took ownership of. As Ruth Meyer said, we needed to take responsibility for what we wanted to see our tomorrow to look like. Is it, as we look at our situation now, how do we defend our democracy? I think that's the question I would like to ask. We fend off our democracy by not leaving parliamentarians to decide what to do with the constitution. I think local government needs to be strengthened at the moment, so that people within their communities, they are able to challenge what is happening where they are governed on their day-to-day lives. And what Parliament is doing and what local government is doing and the executive needs to be brought under much more scrutiny than what we have done in the past. And that means the citizenry need to remember where we came from. We were involved in making the Constitution. We need to take, again, the responsibility to make sure that it works for us. If any of the three branches were to do its work, understanding that the citizenry will call it to account, I think would have a better outcome than it is now. Our engagement as citizens has only been through elections, and I think that's too far down the line. In between, a lot goes on, a lot that is wrong. So it is time that we started changing the relationship between the citizenry and those who are wielding political and administrative power. We need to go back to challenging those that are wielding power and authority to make sure they do that within the confines of what authorizes them to act. The other issue that one would like to address at this point in time is, should we be changing the Constitution? I think only those provisions that require changing. I am not for one, just like Rufus said, that need to be quick to change our Constitution. If Parliament is not passing the legislation that it needs to pass to bring the constitutional provisions to manifest in the lives of South Africans, then Parliament is failing the people. And the legislation can be tested whether it is constitutional or it is outside the purview of the Constitution. It is falling foul of the constitutional principles. So before we do that, I'm one of those who will be saying, let us not tinker with the Constitution, because underlying it are the values which all South Africans are agreed on. The founding principles, we are all agreed on those. And we consistently say South Africa must work to ensure that the people experience justice and they experience equality before the law, and they experience the full benefit of the law, irrespective of who they are and where they come from. So all the issues that we tend to throw around and we say the Constitution is weak, it is because Parliament is not doing enough. And also it means the executive is also not bold enough to implement what their mandate calls them to do. And then we want to rush to change the Constitution. And the courts need to interpret the Constitution. They understand the founding principles. They understand where we come from. They understand the purpose of what we wanted to achieve, because they've been part and parcel of this nation anyway. So no one can say they are outsiders to what the aspirations of the people are. So I would like to end on that note, then hopefully we can take questions. Thank you.
Thank you so much, Advocate Mcholo. I think that is a fantastic note to end on. Just for everyone who's joined, thank you so much for your patience throughout the technical difficulties and some of the issues we had around time. We were meant to finish at 4:30, but I think we just extended to 4:35. We had to disable the chat function at some point, but now it's enabled again. So I would love for you to please share some questions in the chat. As I go through those questions, if others don't come, then I've noted some that I also want to raise. So the first question we have from someone named Zodwa is, how was power imbalance between apartheid leaders and liberation movements managed during the negotiation process? So yeah, I think maybe Rolf or Hassan, maybe one of the two of you want to answer that question. How were power imbalances between apartheid leaders at the time and liberation movements managed during the negotiation process? Hassan, can I maybe ask you to respond to that first?
I'm not sure what one would talk about the power imbalances. Clearly, different parties that were present in the discussions held certain weight because of the constituencies and the background from which they came. So clearly, some were from bigger parties than others. But the power imbalance was clearly ameliorated or settled by the desire to make sure that we just didn't want the constitution to be passed. We wanted a constitution that had the support of the majority. And to have the support of the majority, you needed to take into account the views of the smaller parties. So the smaller parties, you couldn't quite say that there was a power imbalance. In fact, at times, smaller parties had a bigger stake in the power than they really than they deserved or that they really had, because they had the ability to block processes. So hence you'll find in the process at different times there certain power blocks were established between the differing parties, bearing in mind that we're talking up to about 20 odd parties at some point in time. So I think given the smaller parties had an enormous power, so I wouldn't quite refer to power imbalance. It's certainly not my interpretation, but I would defer to what Rolf has to say on this one.
Kirsten, maybe just briefly, I think this question might refer to the reality of the conflict that we had to resolve in South Africa. On the one side, there was the apartheid government that held the power illegitimately in the sense that it represented the minority. And there was the ANC on the other side that represented, according to all records or observations at the time, legitimately was the representative of the majority of South Africans. I'm talking in the period before the first democratic election. And this is what we had to balance out. The one had the power and the other one was entitled to the power. And how to transfer that power from the one to the other in a peaceful way to avoid a further escalation of conflict was the big question that we had to resolve. And unfortunately, our leaders, by the end of the 1980s, on both sides, decided it's better to sit around the table and to find answers than to fight it out as it was escalating the civil unrest and otherwise in the country by then. And so I think that was the major magic of the South African solution. And that is something that people in the rest of the world are still asking us to come and talk about, because they want to find out how did we achieve this to reach this benchmark of an example on how to solve a conflict peacefully where it was seemingly almost insurmountable. And I think that is the wisdom of the leadership and the will of the leadership to find a peaceful solution that speaks so loudly.
Thank you, Mr. Mayor. There's quite a few questions in the chat, so I'm going to try to group them. So maybe Advocate Ntsholo, if I can give you this question. So the participant says, the current electoral system allows you to vote for a party and not a person. The person is allocated to an area by the party and thus has loyalty toward the party and not the electorate. Those elected cannot be held accountable by the populace. And I note you saying in your contribution that sort of the only way that we are holding those in power accountable are through elections, and that the relationship between the citizenry and those who wield power needs to be strengthened, and we need to see how much more we can hold them to scrutiny. Can you maybe give us some examples of constitutional provisions that provide for the sort of accountability mechanisms between citizens and or the electorate and those in power?
Okay, thank you. Right now, we have MPs having constituencies, but those are not working for the citizens because those MPs don't necessarily find themselves accounting to the areas where they come from. So there is a need to amend the electoral system so that we also strengthen the constituency aspect of those who wield political power, as well as the proportional representation. We need to find a hybrid of the system that we currently have, so that those who eventually become the representatives of the people are accountable to the places where they come from, to the people who actually know that they can send them letters and say, this is not going right. In our situation, this is not happening. So we need to amend the constitution. And I think Parliament has been seized with that for some time. Even the Constitutional Court caused them to amend the electoral system. I don't know what's holding Parliament, but therein lies the challenge for the ordinary people. And I think this is one of the areas where we've been quiet as the citizens, instead of now saying enough is enough. We cannot consistently be waiting for parliamentarians to eventually elect an act that is going to make them more accountable and more transparent, because the current system works for them. It doesn't work for us. It works for them because they find themselves floating. They will tell you that they represent the people, but they're floating because they don't proceed from the areas where they come from, and they're not accountable to the areas where they come from. So this current system works for them. So it's time we started agitating that legislation must pass ASAP.
Thanks, Advocate. I think that's a tangible and concrete goal, sort of advocacy around passing that legislation in particular. Is there anything else you can think of besides something that will get Parliament to act and to pass legislation? Because even at that stage, legislation isn't always implemented. And so is there something, or do you think, and forgive me if I'm pushing a bit on the boundaries here, but do you think there's an over-reliance sort of on the Constitution and less of a reliance on active citizenry and protest action and that sort of thing that we saw leading up to a constitutional dispensation?
Yes, to a great extent, I think we've relaxed as the citizenry in South Africa, which is what I pointed to in my input. We have relaxed and become comfortable, and we have somehow thought those elected into Parliament will always do good. Somehow we've put too much confidence in their priorities and in thinking they'll do the best. It doesn't necessarily seem like. So I believe it is time that we as the citizens need to remind them that they have a responsibility to the electorate, to the people that have put them in Parliament. So yes, advocacy needs to be heightened. We need to start within communities where we are to demand more from those who are saying they want to go and serve us. We didn't force them. They put up their hands and they said they want to serve. So let them serve with diligence.
Thank you, Advocate. There's a couple more questions, Mr. Mayor. There's specific questions directed at you. Maybe let me. Okay. So there's some stuff around electoral reform as well. So, Edward and Cholo, do you want me to go to somebody else, or do you want me to ask you this question?
Whatever, you can ask.
Okay, it basically just says how can we leverage the Constitution to ensure that the National Assembly acts based on evidence collected rather than their own interests? And I think you sort of answered that with referring to the legislation that needs to be passed. Is there anything else between elections that gives citizens or the electorate a mechanism through which they can hold Parliament accountable, other than elections?
I don't know. I haven't tested this, but one is not aware of how actively is our Parliament in receiving ordinary citizens' letters of complaint. How serious are those taken up in our parliamentary system, where an ordinary citizen can send a letter, or what one would call a private member's bill, where we write and say, we are not happy with ABC, Parliament, you're dragging your feet in this area, in that area. These are things you ought to have done. I don't know the extent to which those are taken seriously in our own environment. I have not seen any example. Maybe it is done, but I haven't researched it. Because that alone should be an opportunity for parliamentarians to see some of the issues that people are unhappy with on the ground, wherein they are voiced in parliament, and maybe they may be even be read through as part and parcel of the schedule of their business. I think that's the point where citizens can write and complain, and their complaints be put as part of the business of Parliament, so that the parliamentarians can reflect on the issues that are arising from the ground.
Thank you, Advocate Ntsholo. Let me give you a bit of a break. So one of the participants does say community complaints, emails, telephone calls not taken seriously by ward councillors, and that goes all the way up. And I think that's been the experience also from what I've experienced. But let me go to a couple of other questions. So I want to maybe talk about something that's coming off in the chat. So there's a couple of questions around what the participant is calling illegal foreigners, and I do want to correct that and refer to people who are living in the country without documents, either as unauthorized immigrants, and not use the terminology illegal foreigners. But there's questions around pressure being put on infrastructure and municipal systems because of an influx of people from other African countries, number one, and then stuff around the prevention of unlawful occupation and illegal eviction, and how that undermines property rights enshrined in the Constitution. Now, I'll go back to these questions, and I want to frame them as being related to another question in the chat that is around division in the country at the moment. And I do want to talk about the role that the Constitution has played in contributing toward negating that division and truly building a unified South Africa. But I also don't want to totally discard what the participant is saying and not address their question. So, Mr. Mayor, it's particularly directed at you. One is around whether the people who drafted the Constitution intended everyone who lives in South Africa to benefit from the provisions of the Constitution. So that's people who are coming out from outside of South Africa and those who are citizens by being born here. And then secondly, whether PI and that act is undermining property rights as enshrined in the Constitution. And then can I ask you to just, if you can respond as quickly as possible. I know there are a lot of other questions on the chat, and I think what we'll do is we could also just compile those questions into a document, ask the participants to answer on a Word document, and then we circulate that to participants as well, if that will help. But Mr. Mayor, maybe you can do that, and then I'll direct one last question at Mr. Ibrahim. Sorry, you're muted. Let me just ask you to unmute. You're getting an invitation from me to unmute. Nope, still not working. I'm going to ask Zinzi to just help you unmute. And in the meantime, maybe let me direct my question to Mr. Ibrahim. Is that okay, Mr. Mayor? Okay, Zinzi, if you can maybe just get Mr. Mayor's mic working in the meantime. And then Mr. Ibrahim, I want to go based on what are some of the questions that are coming from the chat and on your own input. So I note you talking about the process being more difficult than the substance. And maybe let me also just give my own disclaimer here. Mr. Mayor said earlier that Justice Krichler is in the room and you have to watch yourself. I feel even more responsibility to watch myself. I was born in 1994, so please take whatever I'm saying, knowing that I give you all the respect that you deserve, and I have immense respect for all three of you. But I do want to ask a couple of questions, and I hope it's taken in the spirit of engagement and nothing else. So, if we recognize that the process was more difficult than the substance, and we are cognizant of the fact that what the context showed us was that people were actually at a war with each other, racially and otherwise, and were divided in the country at the time. What do we think the Constitution has done to dispel that sort of division in the country? And why I want to talk about that is because in the preamble to the Constitution, it's clear that the Constitution it says we adopt it to build a unified South Africa. And I know from the Harare Declaration, that is one of the principles as well. And so if we're talking about the Constitution as almost the birth certificate of a new nation, then what is the identity of that nation? And has the Constitution, as that birth certificate, done enough to give us a unified identity? Maybe, Mr. Ibrahim, if you can just talk about that.
Yeah, perhaps let me start by saying that I think the reason why we don't have the country collapsing is because of the Constitution, in the sense that whilst we have serious differences with each other, the legitimacy of the Constitution is never in doubt. The legitimacy of the Constitution has always been placed above all other debates. And so in a sense, what we've got is a very valuable thing, which is respect for that Constitution. We may have a lot of other difficulties and challenges and disputes, and that's fair in a democratic environment, and it is proper for people to voice their differences, to argue, and to do so robustly. But the point is that people still respect the Constitution. We still have people resorting to the courts of law when they have issues of dispute, and because they believe that it is an institution that they can respect. People may have difficulties and challenges with whether people in the executive or in the legislature, but people at least have the mediation of the courts, which they have respect. They have respect for our judiciary, and they have respect for our institutions. And a whole lot of that is because of our Bill of Rights and because our courts are there to be able to deal with it. The second part of it is, I think, the whole of our Chapter 9 institutions. Our Chapter 9 institutions, with all the challenges and problems that we may have, I think are very respected. And so in a sense, there's a whole lot of the Constitution that people still believe in different parts. Now, we had a saying at the adoption of the Constitution that not everybody agreed to every clause of the Constitution, but everybody agreed to the Constitution as a whole. So in a sense, everybody accepted that there were some imperfections in that Constitution. But that is what a nation in the building, in the making, is all about. We're imperfect, and we need to recognize our imperfections. And the only way you deal with it is by continuously trying to find solutions to the problem. So I do think that the Constitution has had a great deal of value, still has a great deal of value, and will continue to have a great deal of value because it is a glue that keeps people together. And that's what I think has saved South Africa from what could have been a different outcome. But that's my view. Thanks.
Thanks. Yeah, I take that point, and maybe if I can just push back a little, but I'm going to need to push back and then ask everybody to give concluding remarks. So maybe on all the questions that have come, I'll mention another one, and then just ask everybody to conclude because I'd like us to wrap up. Maybe just to say, yes, it was it still is a legitimate document, and I don't think that's disputed. But in the conversation that we all had, now we also spoke about people having ownership of this document, and the document being the foundation of the nation's soul. And I do think we need to start to think about to what extent the Constitution reflects the nation's soul when the majority of the nation is poor and destitute, and what the Constitution does to correct that. And whether those people feel ownership of the Constitution as something that reflects their realities and as something that was adopted to better their realities. Because again, the Constitution is not just an ordinary Constitution. It's not just a set of rules. It's literally states in the preamble that it's to better the lives of everyone who lives in South Africa and to give them quality of life and free the potential of each person. And I think that definitely is something that we can dispute. is that happening currently? And it may be due to a lack of political will, as you have all pointed out. There are questions around the liberal democratic framework of the Constitution and its protection of individual rights, which everybody mentioned, and whether that sort of design, instead of communal responsibility or group rights or sort of, more nation building rights, would have had or resulted in better outcomes for the majority of South Africans. And in the current moment where the people feel that the Constitution, and you just mentioned this, Mr. Ibrahim, that it's something that people depend on and they go and they can enforce their rights in a court. But it's not also always true that those rights are vindicated. A court can give an order, but it doesn't mean that that order will be implemented or that people will receive the tangible goods that they are asking for. And Advocate Ntsholo, you also spoke about the nation's input. And I'm interested in when during this process of drafting, and I can totally respect and empathize with how difficult it was to bring together so many different viewpoints and so many actually opposing parties and try to make one document that pleased everybody. But maybe in closing, can you talk about whether you think there was a bit of an overcompromise, if there were things that were left out that maybe should have been put in, if there were things that were put in that maybe should have been left out, and to what extent the implementation of what the Constitution provides almost as scaffolding is reliant on political will. And in the absence of political will, what do we do now? Is it an overhaul of the Constitution, as some participants are recommending, or is it to go back to the Constitution and actually find those mechanisms that allow us to implement accountability and those sort of things to get political will moving? Mr. Mayor, let me start with you. Can everybody just cap their conclusions and answers to 2 minutes, and then we can end off by 22.
Thank you, Kirsten. I enjoyed listening to you now, and it made me think, because I can recall at the time that we were drafting the Constitution, both constitutions, interim as well as the final, specifically when it came to the Bill of Rights, people said to us, but you are aspiring too highly. In other words, you are setting the bar too high. And we were saying, let's rather aspire for the ideal. That is what we want to achieve. And we must always remember, we were coming from a very autocratic state. We were coming from an era of autocracy and almost dictatorship. And we had to find a way to replace that. And in that way, we drafted a constitution that became very liberal in its context. In 94, or 96 rather, our constitution was probably in many ways one of the most liberal in the world. And I think we can still be proud of that. If it fails us today in certain respects, we must always remember that it's better than anything else we had before in that sense. And just on the point, since the questions were directed to me about people who are illegally or without legal documents in South Africa, it's a difficult issue, I totally admit. But this is not only a South African problem. It's far bigger even in Europe right now. And the Americans are struggling with the same thing. So it's something that we have to find a way forward in such a way that we don't disrespect the Constitution on the one side, but at the same time make sure that our normal laws with regard to handling the situation of people without legal documents are actually being followed and practiced and fully applied. I think that is crucial.
Thanks, Mr. Mayor. Advocate Ntsholo, let's go to you. And I just want to also just note a question, because you spoke about this, just a question about what basis is there to believe that changing the electoral system will actually change the conduct of politicians who run the systems. So maybe in your conclusion, if you can also just speak to that.
May I just say, the electoral system is one of the mechanisms we need to change to get politicians to be more accountable. There should be other means. One, if they are located where they come from, that's another one, because from the areas where they come from, they can feel the heat. Thirdly, within the parliamentary system, we need to watch what they are doing in the committees. when they have to deal with each other, be them calling those in government to come and account, and them among themselves if now they proceed from constituencies within their localities. So all those mechanisms can work together. And it gives us even more voice when we have to vote, because we're able to say, you are not working, you can't hide behind your party. The fact is there are no deliverables that we can point at in our community. You've been there and we're still in the same position. So it's a combination of many intervention tools to get them to be more accountable. Now, insofar as the issue of undocumented migrants, the issue of migration, as Rufus said, is a big challenge all over the world. And we need to deal with it with the sensitivity that it deserves. Insofar as rights and responsibilities, they have access to limited, those who are documented, and I dare say even the undocumented ones, they have certain rights within the political rights in the Bill of Rights, meaning the right of the person to be protected, their rights to privacy. There are certain rights that they have access to within the political rights. And then the social economic rights, those should be exclusively for people who are citizens and who have the right to be residents in South Africa. So it's a complex area which needs a lot of looking into. Whether the Constitution is our problem, I don't think so. I think our problem is the political will. Parliament can pass a legislation that deals with communities, that deals with segments of areas that need critical attention. If they don't have political will, we can change the Constitution. They will still be doing the same thing. Get there, be in it, focus only on that which they feel gives them either more power or popularity. So it's not the Constitution that is creating the challenges that we are having. Yes, where it is inhibiting us, but have we even tested those areas? If we haven't tested it before a court, then we cannot blame the Constitution. It is political will that we need to deal with. We need to deal with both Parliament and the executive, because the judiciary can only interpret what the legislation says and what the Constitution says. So if the legislation always falls short of the will to change the lives of the people, you can't blame it on the Constitution. Individual rights have not in any way said where we have the right of association, the right of groups. Those rights are still protected so long as they are not used to impinge on the rights of other communities. Especially because we understand where we come from, we need to fix the disparities of the past. The Constitution enables us, it says so. So it is political will. Our challenge in South Africa is political will. And until we deal with that, we'll keep on hiding and finding all manner of faults everywhere else, but where the fault is. Thank you.
Thank you, Advocate Ncholo. Mr. Ibrahim, do you want to just give a 2-minute closing remark?
Oh, thank you very much. I think it'll take less than 2 minutes, in the sense that I agree with both Ruth and Palesa. I think the Constitution is not a solution. It's not a magic wand. It's not there to solve everybody's problems, and it is imperfect. In all constitutions are imperfect because time evolves and institutions evolve, culture evolves, and therefore constitutions, being legal frameworks within which we operate and society operates, needs to evolve as well. But we cannot find fault with the Constitution where we come short, in the sense that I think it's not just political world, but it's broad society. I think in the sense that where there are imperfections, then we need to find ways in which to correct that. No society is perfect, and we cannot look to a constitution to find that perfection. I think that perfection is something that we strive for in a never-ending sort of way. And I do think that we need to look at a constitution and find ways in which we can leverage value of it to make a better life. Where the Constitution inhibits that, then we need to look at ways in which to change that. But the way in which we change it is through civil society, through political structures, through general activism, and to find ways in which to improve that. But I do think that we are far too prone to find fault everywhere. And that's an easy way out. That's a cop-out. We came through a difficult history to get to where we are at. And what we need to do is to recognize it is not a perfect. It's not heaven. And we need to work harder to take where we are at and move further. There are imperfections, not only in our constitution, but in our society. And those are things that we need to work on. And I do believe that we need to look long and hard at really what is it that we need to do, how can we do it better, and indeed there may be areas of the Constitution that could be improved as well. So I'm all for that, and I do believe that the Constitution will need some amendments, some places, but it does require people to think about it and look at it. But we cannot look for the fault only in the Constitution. We must look at it at ourselves as well. Thank you very much.
Thank you. Thank you so much to you, Mr. Ibrahim, and to you, Mr. Mayor and Advocate Ncholo. This has been incredibly engaging, and we're super grateful for your time. And to everybody who participated, thank you so much for being engaging as well and for bearing with us for running over time. We will definitely follow up with all of the questions that weren't answered and maybe add in some other questions. I may add some questions to the panelists as well, and we'll get that circulated to everybody. So thank you and have a wonderful evening. And yeah, thank you so much again to our panelists. Bye.
Bye. Thank you. Bye.
Thank you. Bye-bye.
Thank you. Bye.
Bye-bye.